to record it. Like Esther said, I'm Angela Clancy. I'm the Executive Director of the BC Family Support Institute. I've been in that role for almost 26 years. And Yuji is actually our presenter for the most part today. And so Yuji Kajiwara and I have been friends for many years. And so a little bit of context, but well, first I'd like to acknowledge that Yuji and I are calling in today from my home office, which is on the traditional and unceded territories of the Katzie and Kwantlen First Nations, colonially called Maple Ridge. And in particular, we're in a really small farming community in East Maple Ridge called Wanik. And as you may know through some of the communication that came out, Yuji is blind. And so for accessibility purposes and to center ourselves in this conversation, I'd just like to describe to everybody that I am, although sitting down, 5'11". I'm a white woman with brown hair. I'm wearing dark rimmed glasses. I'm wearing a gray turtleneck. It's cold out here today.
Oh, yeah, cold here, yeah.
And my hair is in a ponytail. So a little bit of context before I hand it over to Yuji to run us through our presentation. Probably 5 or 6 years ago now, Yuji and I were at a conference together
in Kelowna. Inclusion BC, yeah.
That's at the Inclusion BC conference. And we were both participating in a meeting called the Executive Directors Network. And at that meeting, the public guardian and trustee was there doing a presentation on supported decision-making, in particular representation agreements and committee. And they handed out a chart, and the chart is essentially 12 legal tools that empower or disempower supported decision-making. And so Yuji was really interested in this chart. Yuji is probably the person that I've never met anyone in my life more committed to research and understanding different concepts. So we decided that he decided, and I leaned into support, to do a presentation on what are those 12 legal terms. And I'll show you an image in a few minutes about what that chart is, and we'll make sure you get these handouts. So really the presentation today is the legal framework around those 12 legal supported decision-making tools. And so Yuji's going to walk us through that. He'll tell you what act it falls under. He'll tell you who is responsible and what are the authorities that fall under each of those tools. And we have some exercises. We've got a relatively large group. We've got so far 31. So you were right, Yuji, you guessed 30 people. So
30
far
to
31.
30 to 35.
And so, yeah, we will just go ahead and get started. So I'm going to share my screen. Yuji, do you want to introduce yourself first?
Sure.
Okay, you go ahead while I start sharing the screen.
Okay, I am Yuji Kajiwara. It's a Japanese name. I'm from Spectrum Society for Community Living in Vancouver. You know, by looked after by Ernie Bass. You may know his name. I'm just a client here, and I've been working with Angela for several years now, and this is what I'm here for. So welcome to, so I can start, right?
You can, so we'll go to your first slide.
Okay, welcome to our special presentation, and thank you so much for signing in for this one. Our title is called What is for the Natural Authority, Learning and Understanding the Importance of Natural Authority. So this is our title, and next slide is an introduction of natural authority. So it's going to duplicate what Angela was saying. So when it comes to supporting and looking after vulnerable people with a disability, so-called PWD, respecting their so-called this title, natural authority is highly important.
But sorry, Yuji, can I interrupt for just one second?
Sure.
Esther, can you press record? Did you do that already? We didn't get a message up, so I just not sure. Sorry. Okay. Sorry, Yeah, I wanted to,
Okay.
there we go.
Okay, so
Okay,
it's
you can carry on.
So
Yeah.
I don't need to record mine.
No, you don't. It's
Okay.
being
So
recorded.
you can send it me later, right?
Well,
Okay.
yes.
Okay. So respecting the so-called this title, national authority, is highly important. But what is tricky is can easily get underestimated, overlooked, or ignored. So to talk more about this, we will introduce the 3 items in a simple and easy to understand manner. First one is the basic meaning and importance of natural authority. And second, an introduction of a public guardian and a trustee of BC. You may have heard of this, what they do with vulnerable people with a disability, because this is closely connected with this title, national authority, and nobody can disconnect PGT from this. And the last one is just like Angela said, 12 PGT, legal decision-making tools, which is our main subject to present. So anybody who doesn't know about the connection between not this national authority and PGT will be able to learn easily. And the last one, I'd like to say our mission and the vision statement from this presentation is to promote, empower, and support the importance of national authority to more vulnerable people with a disability in our community and society by educating this importance through PGT tools, and also to foster understanding and commitment of a unique preference and needs to be catered for each person with a disability. So that's what I like to say, and I like to get started. And if you have any question, please feel free to ask me. Otherwise, I'm going to keep going.
So these first 2 slides here, which the font is way too small to read, but you will get them in the handout, is that chart that we talked about that led to us creating this workshop. Okay, so now we're on to your exercise.
So we showed the 2 charts,
I
right?
did, yes.
So this is what we are going to talk about more. Okay, so first one, opening exercise. So there is no and right and wrong answer. What is your personal definition of natural first? Like just a general definition?
Yeah, and feel free to shout out
Yeah,
what you
no
think
right or
is
wrong answer.
the definition of natural.
Something that comes natural to you.
But what is your definition of natural? That's what I'm asking.
Something that you do without thinking. It's just something that automatically is like it's in your nature. I don't know how to
Oh,
explain.
that's
That's a good answer.
Yes.
Isn't it? Yes.
Yes, exactly. Yeah, inside themselves. Yeah.
It's authenticity.
What is it?
Authenticity.
Mr.
Authentic.
Real.
Yeah, real. That's right.
Okay, sure.
Oh, I'm not sure we can hear you.
Oh,
There's a couple of comments in the chat.
Okay.
Instinctive and untampered. Something you were born with.
oh yeah, that's
Nice.
pre-existing like
That's
that.
right.
Innate.
Yeah.
Something inherent. I said that, didn't I? Something you were, yeah, instinctive and untampered.
Yeah. Aaron, do you have something to say?
Yeah, that's great. So what Esther is reading out,
Yeah.
Yuji, is there's a chat where people can write their answers. And so she's reading out the answers that people are choosing to put in the chat rather than voicing them.
Okay.
Yeah.
Understand. Okay, so I think
Excellent. Okay, so you can,
Well-
and there's a couple more in the chat that says without additives or addition from inception,
okay.
everyone has it.
Okay, yes.
Okay.
Okay, so next word, what is your definition of authority, please? Nobody.
They might be putting it in the chat.
Oh,
Yeah,
okay,
here's
okay.
somebody's put something in the chat. They've said power.
Oh, yeah.
That's a common one, isn't it?
Yeah, power. Yeah.
Yeah, the body that governs.
Yeah, that's what I said, governing body. Yeah.
Someone else said who can make decisions.
Yeah, that's right. Officially.
Yeah,
right?
officially.
Yeah,
Yeah,
officially, right? Yeah.
that's right. somebody else said guidelines.
Oh, that's a good
That's a
answer.
good one, isn't
Yeah,
it? Yeah.
we are learning. Yeah,
Decision-making power.
yeah, that's what.
Power is a really important.
Yes, but the power officially, right?
That's right.
Well, anyway, so
Yeah. Okay, so you can carry on.
okay, so here's my definition. Okay, next slide. National authority refers to first one, a person's decision making and controlling power in a specific area, which means in their own life, naturally, in a way of being created by themselves, not by somebody else. I think this is the reason that I think this is a reason why this word natural is used, not by somebody else inside from themselves. That's what I think this word natural is used, belong to them. And second one, a person's own power, and I have added on autonomy, a freedom from being influenced or controlled by anybody else, to make decisions and actions in a specific area in their own life, naturally, in a way of being created by themselves, without but not by somebody else, belong to them. So anybody got this clear? I think it's okay.
Yep, I think that's good. I think you can go on.
Okay, so next one is, I'm sure many of you know this one, but just like to introduce, who is a public guardian and trustee of BC, so-called PGT, a public and government-based organization, so-called a quasi-government, providing guardianship officials legally responsible for protecting, monitoring, and looking after vulnerable people with a disability, called PWD, for their particular interest, which are legal and financial affairs, personal and healthcare decisions. And next one, this is what PGT is for, will be legally authorized to step in, take over, to deal with their particular interest on their behalf if nobody else is qualified or available, which can get controversial. And next one, also legally responsible for conducting an assessment and investigation for any abuse or neglect reported. And last one, formally and legally called, which this is a fancy title called statutory property guardianship. I think this literally means a property guardianship legislated by the government, but it refers to a special legal guardianship title of PGT. So somebody who is highly vulnerable may need and have this. That's it for who is PGT. All right, so next
I think
one.
you're good, yeah.
Okay, three main purposes. One, to learn and understand the importance of national authority through 12 PGT legal decision-making tools, and also to be aware of the tricky balance between protecting a loved one and leaving them alone, letting them make decisions on their own, which is a tricky balancing act to do it. And also third one, to introduce an easy to understand version of 12 PGT tools to prevent misusing and misunderstanding and misusing these tools if you and situation need to use this, because this can result in mistreating or abusing them. So that's all for this three main purpose. And the next one is a brief introduction of three Provincial Act which governs PGT tools. First one, PGT Act. This will duplicate with who is PGT. A Provincial Act which establishes the structure of PGT, describes a list of legal authority and duty to protect, monitor, and look after vulnerable people with a disability in BC for their particular interest. And this act allows them to step in and take over to deal with their particular interest. And I think that's all, right?
Yep.
Okay, so which I
Well,
sort of...
and it allows the PGT to also conduct an
I
assessment and
missed that.
investigation
Yeah.
of any abuse or
Good.
neglect, reported to them.
Yeah.
And the PGT Act and the Adult Guardianship Act both have that function. And Yuji's going to tell you about the Adult Guardianship Act next.
Okay, so Adult Guardianship Act, a provincial act which provides a wide range of decision-making tools for vulnerable adults who have a very low or no mental capacity to make decisions for personal and healthcare decisions, legal and financial managements. Also, this act forms a framework involving family members, friends, close relatives, friends, healthcare practitioner, hospitals, lawyers, police officer, or financial institution or PGT to work together for their particular issues as a team. And next one also provides a list of so-called list of support and assistance plan order for vulnerable adults who have been abused or neglected, who may pose a high risk to themselves or to others, or self-neglected. On a tool, support and assistance court order is established under this act, which we will go over later on. And last one, Committee of Estates certificate of incapability is also established under this act. We will go over later on. Okay, next one.
Okay.
Patients Property Act. Okay, Committee of Person, BC Supreme Court order, and also Committee of Person are also established under this act. We will go over later on. Okay, a provincial act which allows someone else to manage and look after called property for a person called patients. Patient refers to three cases. One, a person who has been diagnosed mentally not capable of managing and looking after their own living affairs, personal healthcare decisions, or unable to perform basic living tasks. And second, who has been issued a legal document, certificate of incapability under the Adult Guardianship Act. And also, third, who has a special legal guardianship from PGT called statutory property guardianship. So either one of these. And next one. Property refers to, first one, needless to say, property and assets. And second one also refers to personal and healthcare decisions for, for such as for a place or facility to live, or a specific type of living assistance they need, or healthcare decisions proposed by their doctor. That's it for Patients Property Act.
Great.
Okay, we are going to,
So just before we move on, so
yeah.
the reason why we explain the all three acts is because many times people with disabilities and their families think that think that the only legislation that supports vulnerable people is the Community Living Authority Act, which is what CLBC reports under. But in actual fact, there are many different sources of legislation that have eyes and a responsibility on vulnerable people. So that would be the Public Guardian and Trustee Act, the Adult Guardianship Act, and the Patients Property Act. And there's also the Mental Health Act. So that's why we talk about this, so that we open the doors of understanding of what the legislative framework is. So now Yuji's going to start from the least restrictive all the way up to the most restrictive in that chart we talked about.
Okay, so we are going to start our main subject, the 12 PGT legal decision-making tool. Starting off with the least intrusive, number one, informal resolution. This is just a title only, not a tool, so it's not so important. We got 3 slides here. First slide is definition. Basically, what this saying is, what this means is you're basically requesting somebody's help in an informal and casual way. This can be at the personally, in your family, neighborhood, friends, or stores you always go, or doctor office you always go, whatever, wherever you go, personally or professionally at your workplace. And so this is not official, so no charge involved, no legal process required. And the next 2 slides are, for example, from PGT. I personally don't think these are good example, but you can take a look later on. Okay, so move to next one. Number two, enduring power of attorney. This is a typically commonly used tool if you want to entrust somebody to manage and look after your legal and financial affairs on your behalf. And this can be applied at the lawyer's office or notary public with a witness required. And this has two types. One is specific. It's just for one bank account only. Next type, second type is called the general. So you can say anything, whatever you possess, like whatever you possess. It doesn't matter how much value it is. And this can be typically used for three reasons. First one is mostly used is a backup plan. If you're suspecting you're going to be mentally incapable, incapacitated soon, you want to entrust somebody to manage and look after your legal and financial affairs while you're still mentally capable. This is what you can apply. Or you may, if you have a physical disability issue, you need to entrust, appoint somebody like, I don't know, could be your wife or husband or your son or whatever in your family or friend. And also this, or if you have a busy schedule, you need somebody to entrust, to manage and look after this. This is what you can apply for. And I'll give you a quick example of this busy schedule. I know somebody who live around here and got a new job offer, moved to Saskatchewan. It's a lady name, but she owned a condo and it was under her legal ownership, and she had to sell off because she had to move to Saskatchewan, and she used this tool to entrust to her husband so she can focus on, keep working and getting packed up. And husband was always mostly staying home, so he was looking after that. So that's kind of an example you can use for a busy schedule. And then this is not applicable for personal and healthcare decisions. So this will be for next one, representation agreement. Okay, then, and who can do it is, as you can see on that slide, and whoever becomes this power attorney will stay active until they revoke or die, so-called enduring. So that's it for enduring power of attorney.
Right. Does anyone have any questions about enduring power of attorney before we move on to the representation agreement?
Okay, so
Okay, I don't think so. So we will move on.
okay, so this is the next one. Representation agreement, section 7 and 9. We got 5 slides here. First one. So this is a voluntary legal documentation to appoint somebody you can trust to assist with your decision making for your personal, mostly for your personal and healthcare, and just a very limited area of legal and financial affairs, which is only routine or minor only. And as I said, there are 2 types, section 7 and 9, and then this is I forgot to say, this is a highly recommended supported decision-making tool. We like to recommend. Okay, next one is section 7. This is for somebody who is mentally capable but highly limited. What I mean by this is that they can express what they want, what they don't want, but they may not be able to understand something technical or complicated. Honestly telling you, that applies to me. Or they may not be understand the monetary value difference. And so that's what this is for. And on personal care, I put CSIL contract, which stands for choice and support for independent living. This is a provincial health authority program. A healthcare provider will go to their house and provide whatever living assistance they need. So it's an alternative option of staying at the facility. They can stay at their house. So somebody can help make decisions to get a right contract for this one. And then this is, as I said, this is a highly recommended, and it's because it's the least intrusive alternative option rather than committee of estates and person, which we will go over later on. Okay, next one, section 9. This is for somebody who is highly independent, just like all of you, but you still need somebody to help legally to, something you're not comfortable, familiar. And then at the last one, I put the not applicable for a large amount of investment. But if it's for section 9, if it's a simple investment, if it's large amount of simple investment, it's totally fine with section 9. I confirmed with your Family Support Institute lawyer. You may know Mr. Jeffrey Light. I confirmed with him. It's okay. Okay, so next one, process. So in an individual is supposed to be fully capable, making individual document, section 7.9, and the witness has to be like in a legal format, and who can do this here. And the last one on power, I said, may also be authorized to make personal and healthcare decisions, routine financial management, except the legal affair, if they become mentally incapable. So this is a backup plan, like I said on the power of attorney. If you become mentally incapable, so somebody can do this for you. Okay, next slide. I got the two examples. Last slide, I got two example. Okay, and then additional, something additional. Okay, first example for section 7.9 is healthcare decisions. So somebody can step in, assist with decision making for this healthcare decisions proposed by their doctor before signing in a legal consent form to proceed with. And next one is for section 7 for routine financial management. As I said, may not be able to understand monetary value difference. So you may have to watch out for them to make sure, you may have to teach them to make sure they like paying bills or putting aside for saving like that, to make sure they will manage their money, routine management carefully and wisely. So that's second example. And the last one I added on, this is an additional option called Advanced Care Directive, which comes out to 10 years ago, 2015. If you don't want to let anybody else to make your personal and healthcare decisions on your behalf, if you become mentally incapable, this is what you can apply for. It's a legal requesting document to provide your desired medical treatment if you become mentally incapable. So for example, you can say, if I become mentally incapable, if I become like this, I want this treatment, not this one. If I become like this, I want this treatment, not this one. So it's a strictly guesswork, but you can still give it a try if you want to. So that's it for representation agreement. Any question?
Is there any questions about representation agreements? And one thing I want to point out is, and it was on the first slide, I saw someone asked if we can get the slides. We'll definitely send them out. A lot of the information, pretty much all the information you'll need about representation agreements is on the NIDIS website. And so NIDIS is oversees and does training and support around rep agreements. There is a misunderstanding around rep agreements, and that is some people feel that the only way it will become a legally binding document is if you register it with NIDIS. It's actually not true. As soon as a rep agreement is signed, it is a legally binding tool. You can still register it, and there's added value to doing that, but it doesn't make it any more or less legally binding. So
Angela, I wanted to mention too, I did it in the chat, but I believe we're offering an in-service on rep agreements in August. So
yes, and actually that's the lawyer that I think it's the lawyer that Yuji was referencing, Jeffrey White, is going to be doing that learning exploration.
Okay.
Thank you.
Okay. Was there any questions? I can't see the chat, so I'm not sure if there's any questions on representation agreements. Oh, yeah, go ahead. Someone has their hand up.
Okay, go ahead, please.
Sorry, I wanted to ask, so if I was to just take a piece of paper and write it, let's say with my sister, and we say we agree when I'm no longer mentally incapable, you'll be making decisions for me, and we both sign, that would be a rep agreement.
I actually don't know the answer to that question. I mean, there is a bit of a process around getting a formal representation agreement put together. So one of the things is you need to name the representative, and then you need an alternate. and there's different numbers of signatures that you need on there. There's different things that it would oversee in terms of, like Yuji outlined, a section 9 versus a section 7. Some are routine only, some can be a little bit more complex. So I don't actually know the answer to that. If you could just write on a piece of paper, it may be that that's more in alignment with an advanced care directive. But I'm not, I'll write that question down and look into it, unless actually, and I might be misunderstanding, have you done that and you've had success in seeing that recognized as a rep agreement, or is it a question?
No, it's a question. I must have misunderstood some information just now about what makes a rep agreement legally binding. Like it's not just NIDAs or the lawyers who can.
No. And so like the Family Support Institute can support you in getting a representation agreement set up. There are actual forms for what a rep agreement formally is. And we can help you fill those forms out and go through the process. We have people who are trained in doing that.
I want to just add as well that the cost to do this is very, very minimal. There's almost no cost. I think I paid $150 to do one for my daughters, but each time that I did, they gave me 10 copies. They filed it for me. They did all the work. All I had to do was sign the paper when it was done. So it is a very affordable thing to do.
Oh, yes.
And simple to do. The forms are, I think, online too. If you go to nidus.ca, you can find what you need. I'll put it in the chat.
Yeah.
Yeah, I forgot to say that.
No, that's okay, Yuji.
Yeah,
it's
easy
fine.
and affordable. Yeah.
Okay, so we're gonna move on to, I'm
Okay,
not sure,
now-
I just want to check and make sure.
Yeah.
There we go. There. Okay, so
Okay.
I've written down your question and I will find out and send it in advance or after the session. But now we're going to move on to pension trusteeship.
Okay, so until number 10, we're going to do a brief introduction until number 9. First one. Okay, number 4, pension trusteeship. This is for seniors who are not mentally capable of managing, looking after their pension, CPP, OS, GIS only, and this is not applicable for any personal income and assets. So somebody else, if they need somebody else to do this, this is what they have. This is a federal government program. Next one. Temporary substitute decision maker. This is for medical decisions only, called the TSDM. So this is for somebody who is not mentally capable of, refusing or consenting for proposed healthcare treatment by their doctor. So somebody can help them make the decisions for that. Then also use as a default option. If you become mentally incapable, haven't set up a representation agreement 7 or advanced care directive, instead of going through a costly and complicated legal court application, you don't have to go through that. A qualified healthcare practitioner and the PGT will step in and find somebody, they will take care of that. That's what this is for. Next one, number 6,
So let's take a pause, Yuji, for
Yeah.
just a sec and see, because we've run through the last 2, pension trusteeship
Okay.
and temporary decision maker, quite quickly.
Okay.
So is there any questions or clarification needed on either one of those?
Could we see the slide on the pension trusteeship again, just
That.
briefly?
Oh,
Thank
There
okay.
you go.
So I think it's
Okay, so mainly for
Understandable.
seniors.
so this
Yeah,
is,
it is for
Okay.
seniors.
yeah, this
All
is a
right.
federal government program.
And this would also qualify for seniors with disabilities.
Oh, yeah.
Okay, so we've done temporary
Okay,
substitute
and the next
decision
one is
maker.
for number 6, designated agency, DA, legal mandate to investigate. This is for DA only, not available for us. So DA refers to CLBC, like hospitals or care facility, or a provincial health authority, like Fraser Health Authority, etc., and BC only. And this is what they can do. And this is a legal mandatory tool. Mandatory tool which ensures DA will investigate, protect, and look after vulnerable adults who have been abused or neglected. So this is what it is for. And the next one, number 7.
So hang on one sec. So I just want to
Yeah.
also just put a bit of a fine point.
Yeah.
So the designated agency that is responsible for people with developmental disabilities is CLBC. And then the designated agency that is responsible for investigating either abuse or neglect of people who do not qualify for CLBC would be the health authorities or Providence Healthcare. And so if there is a suspected abuse and neglect of a person who has a developmental disability, it's CLBC, and they're considered, their title is adult guardianship facilitators. So they're the ones who do the investigation into abuse and neglect. And that falls under, like Yuji said, the Adult Guardianship Act.
Okay, next one is number 7, PGT, investigation of attorneys, representative, and committees. This is for PGT only. This still will allow PGT to conduct an assessment and investigation for any physical abuse or neglect to extremely vulnerable adults. So that's what this is for. And the next one is number 8, PGT.
Oh, hang on, Yuji,
Did
there might be something in the chat here.
Okay.
You know what? We're getting to committee, and so we will talk about your question in just a minute because this is actually a very common problem. So the comment in the chat, Yuji says, I have a problem with the TD Bank not accepting my committee designation for my daughter who's disabled.
Okay.
And they ask me to provide power of attorney signed by her, which is impossible for her to do.
Okay.
I cannot manage her bank account properly because of this. So I personally have had this exact issue. I have committee, and so we'll talk about this when we get to committee.
Estate, right? Okay.
Of a state or person, actually. So,
Okay.
So the PGT investigation, what this slide is also saying is, if there is any concerns around a power of attorney, around representative who's named on a representation agreement, or a committee, the PGT has a duty to investigate those concerns. So like Yuji said, this really isn't anything to do with us, unless you're a committee or a representative or a power of attorney who has eyes on you and there's concerns relating to you. So the next one is your PGT protective powers.
Okay, next one, number 8, PGT protective power. This is again for PGT only. This tool will allow PGT to conduct an assessment and investigation specifically for any financial abuse or neglect to extremely vulnerable adults, and also allows PGT to protect and look after their assets if necessary. Then typically this is used for an emergency if they need their assets protection right away. So that's what this is for. And next one is—
Do you want to talk about the power and how long they can freeze a bank account
Oh,
for?
sure. So this is they can freeze and freeze their assets account access for 30 days and renewable to a maximum of 120 days until finding out what is going on, and to protect and look after their assets in a safe and secure manner.
Right.
So, okay, so that's what this is for. And next one is number 9, support and assistance court order. This is for court order only, and this is a legal court order request by PGT and designated agency, which Angela explained earlier, for vulnerable adults who have been legally and medically assessed, mentally not capable of performing their managing and looking after their own living affairs for personal healthcare decisions, unable to perform a basic living task. So court, what they do with this is court will select and outline a list of support and assistance plan order from this Adult Guardianship Act Part 3 to tailor each adult requirement. And what is controversial is they do this without their consent, and this will last for up to 12 months and renewable for up to 12 months more. And the next one is number 10.
Does anyone have any questions about a support and assistance court order? It also bleeds over into the next section, which we're going to be talking about, which is comity of estate and person. Okay,
Nobody?
not that I know of. I don't see any hands up.
Okay.
Nope, you're good.
Okay, next one is number 10, Committee of Estates. It has two types, certificate of incapability and BC Supreme Court order. And we got 4 slides here. First slide, a legal process of assessing and appointment a committee of estates for an adult who is not mentally capable of managing and looking after their own estates, which refers to property and assets, which is obvious. Then this must be used as the very last resort if a representation agreement 7 or enduring power of attorney is not a viable option for them. Okay, next one, certificate of incapability, medical, governed under the Adult Guardianship Act. Okay, so process. This legal document will be issued to PGT for an adult who has been medically certified and assessed by 2 qualified physicians, stating they have lost their mental capacity and capability to manage and look after their own estates independently. So which is like labeling them, they can't do it independently. And this document will allow PGT to step in and take over to manage and look after their estates if nobody else is qualified and available. And the next one is who and power PGT only, and will be legally authorized and responsible for managing and look after their estates on their behalf. Okay, and next slide.
And so just to differentiate between 10A and 10B, which
Yeah.
we're about to talk about, the certificate of incapability is when you want the PGT to step in on your behalf and they become the committee of estate. The next one is if you have someone else stepping in as the committee,
good.
like a friend or family.
Yes.
Yeah.
Okay, next one, BC Supreme Court order legal under the Patients Property Act. So also, this can be used if you're not happy with that certificate of incapability decision. This is also something else you can fight for. We don't want to let anybody PGT do that. We want to do it like that. This is something you can fight for. Process, a court hearing with 2 physicians' affidavits examined for the last 6 months. Court hearing it's going to cost you $7,500 plus 2 physicians' affidavits. So I'm suspecting it's going to go close to $10,000. And who can do it, as it says, any capable and reliable family friend and a trust company or PGT, which you don't want, and whoever becomes committee of estate will be legally authorized and responsible for managing and looking after the estates on their behalf and must be accountable to PGT. So you cannot do whatever you want. You have to be accountable to PGT. And that next slide is an example, which is which is typically used example called car accident injury. A 30-year-old male adult has become severely injured at a car accident and has become mentally incapable of managing and looking after his own estates independently, which he left behind. And so a committee of estates, his committee of estates will be legally authorized and responsible for managing and looking after his estates left behind and must be accountable to PGT. So this is a typically used example.
There is a question in the chat, Yuji.
Okay.
It says, what's the minimum threshold for an individual on PWD or a person with a disability to be determined that they are incapable of making their own decisions? When are these assessments done and how do you request one?
Oh, I don't know.
So there's a couple of things. When you're applying for committee, either of estate, which we've just finished talking about, or committee of person, which is coming up, you need 2 medical health practitioners to write a letter or actually do an affidavit that certifies this person is incapable of making decisions on their behalf. And one of the things that we can talk about a little bit more after we're done presenting on comity of person is that once someone has been deemed incapable with the letters from the doctors in the Supreme Court, which this one is, it is almost impossible to reverse it. It becomes a legally binding, permanent
Legally binding.
circumstance that then if you want to empower decision-making later, it's very tricky to do that. And it can be extremely costly to try to reverse it. And what we've heard from lawyers is 99% fail rate for reversing an order of comity once it's been put in place.
Yes.
So, but in terms of the threshold, I don't know of an actual threshold. There is a threshold under a certificate of incapability that needs to be used as the litmus test for doing that. But for the Supreme Court order, it's 2 letters from healthcare
Actually,
practitioners.
I got to answer. They have threshold. They have to go over a manual, legal written manual called a practice guideline.
The practice
So
guidelines.
they have a
okay.
threshold, right?
Ye-
So they, I just remember,
Great.
they have to go through a legal, 2 physicians, like they have to go through a legal manual called practice guideline. This is how they can determine this person is completely
Incapable.
Yeah.
Okay.
So they have threshold by practice guideline.
Excellent.
Which they have to go.
And we
legally.
can see if we can find that practice guideline and send it out after the presentation.
It's a legal written manual.
Excellent.
Yeah. Okay. Yeah. That's
You're
the,
on to-
I think that's the answer, right?
Yeah, it is.
Okay.
Thanks, Yuji.
Yeah. Okay. So, okay. So and next one is a committee of person. Number 11, committee of person. This is strictly for personal healthcare decisions. Also, a family placement or facility placement decision. Okay, governed under the Patients Property Act, a legal process of assessing and appointing a committee of person for an adult who is not mentally capable for making decisions for their physical care refers to, which I just said. First one is a place of facility to live with along with a specific type of living assistance. Second one is just a specific type of living assistance. And third one, healthcare or medical decisions proposed by their doctor. So either one of these or 2 of these or 3 of these. And this must be considered as a very last resort if representation agreement 7 is not a viable option for them. Okay, and the process is a court hearing with 2 physicians' affidavits, but it doesn't have to be examined for the last 6 months, like a certificate of incapability. Doesn't have to go like that. Okay, next one is who can do it is any capable and reliable family or close friend preferred or PGT, and whoever becomes competent person will be legally authorized, responsible for making decisions related to their physical care and also responsible for monitoring or checking if them for their well-being. And the next example is a construction site injury. A 30-year-old male adult got severely injured when working at a construction site, has become mentally incapable of managing and looking after his own living affairs, such as personal healthcare decisions, unable to perform basic living tasks. So his committee of estates, person will be legally authorized and responsible for making decisions related to his physical care, and also they have to monitor or check in for his well-being. So that's an example of this committee of a person, and this can be used as a combination, if necessary, with a committee of estates, if necessary. So I think I got.
Yeah, and so I want to go back to the question or the comment in the chat from the
Yeah.
person who struggles with the bank. So I'll share a little bit of a personal situation. I had joint comity for my brother. So I'm a family member. I have a brother with complex developmental disabilities as well as healthcare needs and a physical disability. I had joint comity with my mom from 2010 and she had comity for him since he turned 19. He's 48. When she passed away last year, I became the sole comity. He does not live with me currently, but I needed to step in to managing. There's comity of estate and person in my situation. So I needed to step in and take over all of his finances and make sure bills are getting paid, making sure his PWD is managed. And I too had the same challenge when I went into the bank. They did not recognize an order of comity. And it's very common. Banks don't go through training on understanding rep agreements or comity. So what I did do was I connected the bank to the PGT facilitator or the person assigned to my brother. And I asked them to talk to the bank and talk to them about the authority that comity has. And as soon as I did that, it opened everything up. And I now have full access
Hold
to
on,
everything.
Not CLBC facilitator. You
Not
said,
the CLBC.
no, you just said a PGT facilitator,
Yes.
not CLBC?
No.
Okay, okay,
Yeah.
okay.
It's so when you have an order of comity,
Okay.
there will be someone assigned to you, to your case, that oversees your account. I can't remember their exact title. I call it the PGT facilitator.
Oh, I see.
But nonetheless, when you have comity of estate or person or both, you also need to report to the public guardian. Some people have to report every 1 year. Some people report every 2 years. And what that reporting looks like is you need to ensure the individual has a tax return. You need to account for if they have an RDSP, any assets they have, any liabilities, which would be tricky because when you've been deemed incapable by the Supreme Court, you are actually not legally legally allowed to sign any sort of legal contract. So you know, you would have to have the comity do that on your behalf. That filing to the public guardian and trustee every year or two has a fee attached to it. And the fee, there's a threshold in the Public Guardian and Trustee Act that tells you how much you have to pay when you're doing the filing. I noticed something came up in the chat, so I just want to read. If a parent is the sole comity or all, I can't really see that whole, no alternate for their adult, when they pass away, yes, that's another thing that I wanted to indicate. So it is, if someone is going to go towards having comity, which we would caution against because we do have an option now of the representation agreements that have similar authority. However, if you do not have a joint order of comity and it's a sole comity, if that person passes away, it defaults automatically to the public guardian and trustee.
Oh, I see.
And one of the things that can be tricky about that is the public guardian and trustee, when there's an order of comity in place, really is just responsible for monitoring the comity. They don't actually know the individual with the disability intimately. They don't know much about their healthcare needs. They don't know much about their capacity or their desires or, you know, choices, things like that. And so when it defaults to them, they really are just stepping into a statutory requirement of overseeing finances and some routine healthcare, but they are not responsible for ensuring quality. That would be the responsibility of adult guardianship. So if someone were to, if the comity were to pass away, the public guardian would need to work in concert with CLBC or adult guardianship to ensure the quality of care. And I see the bank told somebody to sign, I don't know why these comments get in the way, sign a power of attorney instead for her daughter, to have the paper signed for the bank. So the one thing to note is Comity sits above power of attorney. So as soon as there is an order of comity, any powers of attorney that were in place are null and void. And if a new power of attorney is created, it too is null and void. So you can't have both a power of attorney and comity, because comity is the decision-making tool for finances. Great. Okay. And if you have any other questions about comity, one of the things that I will send out after the presentation is we have a YouTube video. We still have a couple of slides to go. I know we're running a little bit behind, but we have a YouTube video with a lawyer who used to have a very boutique law firm specializing in disability estates and trusts. It is a presentation with him talking about representation agreements, and the public guardian is in that video talking about orders of comity. And it's about a 2-hour video that is still relevant today, even though it was done a couple of years ago. So I'll send that link out as well. So now we have a bit of an exercise. We've done a lot of
I don't know,
talking.
not exercise, warning.
Oh, okay. You want to do your warning, right?
Okay,
Sorry.
just want to give you a quick warning. So, committee shift, which we just went over, committee of estates person, it's an extremely intrusive option, and because this will take away.
Put your head down so we can hear you.
Yeah,
Yuji.
this will take over their national authority, so-called their national authority, to make decisions for their legal and financial affairs, or make decisions for their physical care. So this must be considered as the very, very last resort. If no other solutions, such as representation agreement 7 or power of attorney, is not literally a viable and possible option for them. So that's what I like to stress out. And next, that's it for number 11, 10.
And there is a comment here that says committeeship is invalid if someone has a mental health certificate. So one of the slides that's coming up is around certificate of, or a mental health committal.
Yeah.
And so we'll talk more about that in just a minute. Although I will say, I don't know, I haven't heard that before, that if there is a mental health committal that the committee is null and void. It's my understanding that it's the committee's responsibility to oversee that committal. So I'll look, I'm going to write a note to myself and look into that a little bit more, because I've never heard of committee being null and void if there's a mental health admission. Okay, so we have an exercise here. You want to go ahead and
Okay,
explain?
maybe, yeah. Okay, so what are your thoughts of the difference between this committee shift and representation agreement, please? Any answer, please?
So we'll just give it a minute in case people choose to put it in the chat rather than
And
speaking up.
I want to ask something or make a comment.
Sure.
One of my big concerns is the representation agreement is the choice of the individual who agrees to it. And if they change their mind, and of course, with some disabilities, as soon as you suggest something they don't really want to do, then they just say, I don't want you to be my rep anymore, because I don't like what you're telling me.
Oh, I see.
And so have you heard that before? And do you know anything about how you go about ending a representation agreement?
Yeah, so you're absolutely right, Esther. It is,
I see.
it's one of the differences, right, between a representation agreement and an order of comity, is that a representation agreement is a supported decision-making
You can
tool,
cancel.
and you can cancel it.
Yes.
Whereas an order of comity is almost so you'll sometimes hear people say comments like, I have a representation agreement for my daughter. when in actual fact, if you reframe that language, it is my daughter has a representation agreement and I am assigned as the representative.
Oh, I see.
So it is an empowering tool for decision making. You're absolutely right. If that daughter decides to cancel it because she doesn't like what you have to say, then that is her right to do that. She would have the right under a representation agreement act or under a representation agreement to cancel it. Whereas a committee is almost as though you are stepping into the shoes of the individual and making all decisions on their behalf. So it isn't empowering decision making, it is removing decision making and giving it to someone else. And so that's why we talk about, it is highly intrusive, because often in community living, we talk about empowering choice. However, sometimes people need more intervention and support for their decision making than others, particularly if they're at risk. So you're absolutely right in that analysis. I see there's a
Okay.
Yeah.
representation agreements are a BC only tool. They're unique to BC. And as a matter of fact, people are kind of watching BC as we unfold this decision-making tool. And somebody else said, I wish there was something in between.
I forgot to say.
Yeah.
Yeah, I could have. Yeah.
Yeah.
Yeah. So does anyone want to comment? Oh, and the rep agreements may still be, so a rep agreement may still be vulnerabilities to external people,
Yeah,
be
that's
it
right.
like a new girlfriend or boyfriend.
Yeah, that's right.
Yeah, so you're absolutely right.
Yeah.
It can be, it can be tricky. And I think, a rep agreement is almost like, if you have a rep agreement in place, you also would want a circle of support around that individual, so that but maybe when they decide they don't like something that their representative is suggesting, people around to talk about, why don't you like that? What are the alternatives? So it is more of a back and forth communication supporting tool. Whereas the committee can just come in and make those decisions. I will say there are significant flaws in our system around how an order of committee is managed as well. So like I said, I've got committee for my brother. He is in a situation where there's abuse and neglect in his adult guardianship. They did an investigation at my request. They found, yes, he's being abused. Yes, he's being neglected. Yes, there's financial abuse that is significant, and they're not going to do anything about it. So, so I now have the choice as committee to go to court, and it would cost about $35,000 to have a court order to remove him. And the chances of success in that are actually very low, because adult guardianship has more authority than a committee. So if you go to court, the judge is going to ask, why didn't adult guardianship remove him? And they usually will side on behalf of adult guardianship rather than the committee. So it's a tricky situation that can also be very costly, and there's still flaws in that as well. I think I saw a comment come up, and I just want to see. Is a disabled individual practically declared as an adult child with the, so, I mean, if you wanted to use that language, then yes, so the way that I describe it is, I'm my brother's legal guardian, which in the adult world, there isn't such thing as a legal guardian unless you have an order of committee. A rep agreement doesn't give you that. Whereas for minor children, you are the guardian, which gives you decision-making power. So ultimately, yes, it is considered that. In terms of a microboard, so the next question, Yuji, is, do microboards have a role?
For what?
So
Do
a microboard is a mini society
I
that
know that.
wraps around an individual.
Like,
And so I actually don't think they do. I think what the role of a microboard would be is that circle of support around someone who has a representation agreement. But in terms of committee, a microboard would not have role because it is one individual or joint individuals who have the decision-making authority. If they choose to enroll the microboard, they can, but they don't have to, and there's no legislation that says they have to. And then somebody also said, there we go, microboards have no legal decision-making capacity. They're a support. And then someone said, please correct me if I'm wrong, committeeship takes away their rights. Yeah,
that's right.
I mean, in essence, it does, although you will see in the Adult Guardianship Act and the Public Guardian Act that they do talk about, even if there's an order of comity, you want to empower decision-making still. So you want to presume capacity, even if capacity has been deemed to be low or not available through the healthcare practitioners. They do still support decision-making in their act. So it is a little bit tricky, but you're right, it does take away their rights. So we'll run through, we were talking about what's the difference between representation agreement.
So review, right?
So this is your review.
Okay, so here's my answer. Here are my answer. First one is a representation agreement. It's a less intrusive option, mostly for personal healthcare decisions and just a minor, and they can do minor legal and financial managements. And also next, this is a highly recommended, supported decision-making tool, which their voice and choice, so-called national authority, would be heard and respected, and which governed under this Representation Agreement Act strongly support their national authority. And the third one is conversely, committee shift is an extremely intrusive option, which will disempower and take away the national authority because of the mental capacity issue. And this is from the Adult Guardianship Act and Patients Property Act, which involves court and take away the national authority. Then the next one is a representation agreement is an easy and affordable legal document application, plus easy to reverse and cancel whenever they want to or need to. And then on the other side, committee shift is a costly, complicated, and time-consuming legal court application, and almost like Angela said earlier, almost impossible to reverse. And last one is representation agreement can privately monitor themselves, but committee shift is constantly monitored by PGT. So that's kind of a brief summary of this answer.
That's right.
Okay, next one is number 12, last one, mental health committee. And also I'd like to introduce what Mental Health Act is, which governs this tool. A legal order or medical process of conducting an involuntary medical assessment, treatment, and placement for people with a severe lack or loss of their mental capacity, so-called psychiatric patients, and who can pose a high risk to themselves or to others. And this is for people who have mental illness, brain injury, dementia, or substance abuse related disorder. Okay, next one. I'd like to introduce this is Mental Health Act, which governs this. Still is a provincial act, which provides a list of authority, criteria, and procedure to conduct an involuntary medical admission and treatment for people with a severe mental health disorder called psychiatric patients, and also serves three purposes. One, ensures the psychiatric patients will receive a proper treatment and protection in an efficient and lawful manner. And next one, also allows directors of designated facility, which are psychiatric institutions, psychiatric assessment unit, PAU, in hospitals, etc., to exercise their legal authority to treat and protect them in an efficient and responsible manner, and also a tribunal organization called Mental Health Review Board is also established under this act in 2005 to review and improve mental health treatments in a timely and reliable manner. And that's it for this Mental Health Act. There's a process, medical certificate required for a 48-hour psychiatric assessment. Also within this 48-hour period, a second medical certificate required for like a committal to a designated facility. Then no substitute, this is for designated facility only. And last one, the directors of designated facility will be legally authorized, responsible for making psychiatric treatment and the decision treatment and placement decisions based on their diagnosis. That's it for number 12, mental health committal. And I can move to next
You
one.
can go to the
And
next
the
one.
last exercise, okay, to finish off. No, not last exercise. So this is a brief summary. So this is how we did. So number 2, from enduring power of attorney for legal and financial management leads to intrusive, and then representation agreement for personal healthcare decisions and a temporary substitute decision maker, which will gradually get the intrusive, more intrusive, and then move to number 10, committee of estates, and 11, committee of person, which becomes more extremely intrusive. And the last one, which I just did, number 12, mental health committal, which is the most intrusive. So this is how we did. This is
Yep.
what we did. Okay, then finish off with last exercise. What is your short and brief statement?
What is your short and
and
brief statement
yeah.
about what you've learned from this presentation?
Yeah, in terms of national authority? Any like a comment or
Yeah. So
like
we'll wait and see if anything comes up in the chat.
yeah.
Or if anyone wants to shout out.
It's quite overwhelmed, but at the same time, I understand there are many options to choose. And if we lost, probably there someone can help me. That's good to know.
Yeah, absolutely. And it is overwhelming and it's complicated. And another thing is, you know, like Esther pointed out, we really try hard to empower personal choice and decision making. And sometimes the personal choice and decision making really scares us as a parent because it might be not something we choose or it might put someone at risk. And so there are options available to try to protect people if they are abused or neglected. And I will point out as well, self-abused or self-neglected. And so they do all intertwine. It's a lot of information in one workshop, but it's really important. And we will, like I said, send the slides out so you can look at them carefully and make sure that you understand how they all are connected to one another. And I see there's a couple of things in the chat.
Okay.
Lots of things to think about in terms of the continuum of how to support the person's decision-making in respectful ways.
Okay, sure.
And then there are many loops and obstacles to connect all acts and properly protect the person
Oh, I
with
see.
care.
All right.
Absolutely.
Yeah.
Thank you. So this is Yuji's statement. It's up to you to talk about your
Okay, so
final
here's
statement.
my statement. Like, this is what I think I learned with Angela through this process. I personally believe what I learned is the national authority belongs to anybody. It doesn't matter what level of mental capacity they have, always exist inside themselves. That's, I think I learned. So we don't want to assume, I personally, we don't want this person becomes mentally incapable. Oh, their national authority disappeared. I don't think so. It's still inside themselves. They cannot just express it. So that's what I think we need to express. We always have to put in our mind and respect and work with them. That's what I think I learned.
Yes.
Right?
Thank you, Yuji.
Okay.
And there was one final comment
Yeah.
that just said, can you please clarify self-abuse and self-neglect? Would this include someone being taken advantage of financially? So absolutely it does.
Yeah, it does
If
both.
the person is under the support or care or eligible for CLBC, that responsibility falls to CLBC's adult guardianship. And I can say from personal experience, this is actually the impetus of what my brother is going through. The person he lives with has financially exploited and abused him for over a year now. And adult guardianship needed to step in and do an investigation. And at the same time, they did also involve the RCMP, who is doing a criminal investigation into that. Having said that, they haven't removed him, so he's facing that ongoing. If the person is not eligible for CLBC, the responsibility falls to the public guardian and trustee. And then they may refer out to those designated agencies responsible for non-eligible CLBC, which would be Providence Healthcare or the health authorities. So I just want to see, I saw another comment come into the chat, Yuji, and then we can, is there someone I can call at CLBC? Whoopsie. Is there someone I can call as CLBC keeps saying it's her choice? No, it's definitely not. And so this is where, unfortunately, our systems can have people slip through the cracks, and that's where you need to be a very strong advocate. And we can support you in that through the Family Support Institute, knowing your rights, knowing who to talk to, how to initiate a formal investigation, because it's not okay to say it's her choice. And as a matter of fact, there are agencies all across the province who are doing tremendously good, positive work. And we want to, kind of acknowledge that. And sometimes things lead to abuse and neglect, or self-abuse and self-neglect when we sit too heavily on self-determination and choice. So I've seen examples of where agency or support people will say, well, yeah, they haven't had a shower for 2 weeks and they haven't done laundry and they don't brush their teeth, and they actually only want to eat Kit Kat all day, but that's their choice.
Oh, I see.
And there is a very, and this is what Yuji was saying at the very beginning of the presentation, it is a tricky balance between self-determination and choice that can slip into disempowerment or abuse and neglect. And it is very, very difficult to navigate. Comments are coming in, so I just want to see. Amazing presentation.
Okay, thanks so
Well
much.
said. Thank you so much for taking the time to
Thanks so
present
much.
it. And they're going to be calling us.
Okay.
Okay, so we're on to, you wanted to just, there's a list of names
So
here.
this is a special big thanks who help us, including Angela and Carla Bursher, Inclusive BC, and people from my office, Ernie, etc.
Yeah.
Yeah, I don't know, those stuff from Spectrum Society, but I'm sure everyone knows that. Yeah. Yeah.
And so Yuji, there are comments coming in. That does, we've kind of done a Q&A, but if there's any other questions, and I'll maybe stop sharing so we can see people. If there's any other questions, please, we're open to hearing them. And if we don't know the answer, we will get back to you. Just give it a second to see if there's any other, just lots of thank yous coming through and
thanks so much.
excellent information in the chat.
Okay, thanks so much.
Aaron's trying to say something.
Hi, Aaron.
Hi. I'm struck
Okay.
by the differences between what we've got in BC and how lucky we are that we've got had such a good history of advocates working for these things. We've been dealing with some folks down in the States where comiteeship is the sort of de rigueur for folks with disabilities of all kinds. And so, our son, there's some decisions he can't really make because of, his brain.
Yes.
There's lots of decisions he can make. and trying to talk to them about trying to talk to American lawyers about these ideas. It's like they want to learn, but they don't have a system that allows them to really
Yeah.
think these things through. So
Absolutely.
thank you.
Thanks for that, Aaron.
Yeah.
Go ahead. I see a hand up. Is it Von Guy? I'm probably totally not getting that right.
All right.
Sorry, you're on mute.
Mute. Oh,
There we go.
okay.
She did great with the name. Thank you. So I'm not sure. I had put in a question earlier to just ask about, as a service provider, if we're suspecting financial neglect, with an individual who should be on OAS, would the pension trusteeship help with?
Right, I saw that question.
I don't
Yeah,
think
so
so.
it would be the pension trusteeship
card.
that falls. So this is a person who is this person eligible for CLBC or no?
Yes, they are.
They are. So you know what? I think it would be a combination of both. It would be adult guardianship, which is CLBC, and
Okay.
they would likely enact the pension trusteeship, which would come under the public guardian.
I see. I see.
Yeah.
So both I see.
So because it's to do with that,
Pension.
if it's
pension.
suspected financial abuse about pensions, then it would be a combination of both.
I see.
Yeah.
Thank
Oh,
you.
And
no, no, hold on.
I can clarify
I
that
think
in
it will be
particular.
combination. I think I personally, it's going to be combination of pension trusteeship and designated agency, right?
I think
That's-
and the designated agency.
It's a combination of pension trusteeship and designated agency, right?
Right. And for
Okay.
the designated agency, it would be CLBC
Yes.
for a person with a developmental
Yes.
disability.
Yeah.
Yeah.
Okay.
Yeah.
Thank you.
Thank you. So I see there's just a couple more comments. I'll make sure if the person is in care, if the person in care is provided by an agency contracted by CLBC, how a committee can regularly supervise the quality of the service. You do not have limited power when the person is supported in an agency with CLBC. Absolutely not. You still have the same power and authority as committee as you do if the person were living in your home or living away from your home. So you would, so the age, and that's kind of the tricky part is some agencies don't understand an order of comity. And agencies have been trained and do a very good job around self-determination and choice and natural authority. And so it's again, this education information piece, because agencies will want to empower decision-making and a committee is in those shoes. So, and you would hope that the committee would go in and, you know, try to still have some sort of decision-making, but some people can't make all particularly important decisions. So it would be a partnership. And then a person can choose or opt. Oh, here we go. Somebody put a link in. So that's great. So it says a person can choose to opt for pension management assistance if there are financial abuse concerns, and they put a link in the chat. So we can resend that link out in the chat from the chat when we send our follow-up. Okay, so we will make sure we send out the recording, a few resource links. I have a couple of questions written down. We'll send the practice guidelines for practitioners.
Yes.
And any other resources we can think of to make sure that you have all the information. And if you have any further questions or support needs, you can always call us. Great. Thank you so much, everybody.
Okay. Thank you so much for joining our presentation.
Thank
Thank you
you.
So
both.
much for your comments.
Bye.
Thank
Bye-bye.
you.
Thanks much.
Thank you.